Now it is my great honor to introduce today's commencement speaker, United States Supreme Court Justice John Paul Stevens. Justice Stevens is one of the longest-serving justices in the Supreme Court's history. He was appointed to the court in 1975 by President Gerald Ford and served for more than 34 years. From 1994 until his retirement in June 2010, Justice Stevens served as the court's senior associate justice. In that role, he assumed administrative duties of the court whenever the Chief Justice was unavailable and assigned opinions whenever the Chief Justice was not in the majority. He penned two landmark decisions in the last decade regarding due process and limits to executive power, Rasool versus Bush in 2004 and Hamdan versus Rumsfeld in 2006. Following his retirement, he published a best-selling memoir in 2011 containing his recollections of personal and professional interactions with 5 different Chief Justices, from Fred Vinson to John Roberts, entitled 5 Chiefs, a Supreme Court memoir. His most recent book, published just this year and also recently added to the bestseller list, is entitled 6 Amendments, How and Why We Should Change the Constitution. This book explores how we can revisit some of the fundamental tenets that define our identity as a nation. Justice Stevens received his bachelor's degree from the University of Chicago and his Juris Doctor degree from Northwestern University School of Law. He served in the United States Navy from 1942 to 1945, working in communications intelligence during World War II. He was a law clerk to Justice Wiley Rutledge of the United States Supreme Court during the 1947 term. He was associate counsel to the subcommittee on the study of monopoly power of the Judiciary Committee of the U.S. House of Representatives from 1951 to 1952, and a member of the Attorney General's National Committee to study antitrust law from 1953 to 1955. He practiced as an antitrust lawyer before being appointed to the United States Court of Appeals for the Seventh Circuit by President Richard Nixon, where he served as a judge from 1970 to 1975. We are deeply honored that he is here today to help celebrate our graduates, including his own step-granddaughter, Ashley Silver.
Thank you very much. Let me begin by congratulating each of the 468 members of the graduating class on the successful completion of your studies at this fine law school. You are entitled to take pride in your achievement and to enjoy a period of healthy relaxation before moving on to the next stage of your career. My task today is an easy one. Because this is such a happy occasion, you will almost certainly welcome my comments if I adhere to the cardinal rule that should govern all commencement speeches. Keep it short. I plan to do just that. Rather than delivering a sermon, I will merely provide you with 4 pieces of advice and make one request. The first 3 briefly reiterate comments that I've offered to young lawyers over the years. The 4th is the product of reflection about the Supreme Court's recent decision invalidating the conviction of a man who had violated a federal criminal statute by falsely claiming that he had been awarded the Congressional Medal of Honor. And a single paragraph will describe my request. First, I urge all of you to include professional work for which you will not be paid in your regular agenda. I make this recommendation not merely because there are so many people without adequate financial resources to pay for needed legal assistance, but more importantly, because you may underestimate the value of the benefits that you will receive from such work. Perhaps I was especially fortunate to have two such assignments give me the opportunity to argue cases in the Illinois Supreme Court, and to have a third play a role in my appointment to the federal bench. In all three of those cases, I acquired valuable insights in unfamiliar areas of the law. One involved a challenge to the constitutionality of an Illinois divorce law imposing a so-called cooling-off period that violated the plaintiff's right to a speedy trial. The second involved a murder conviction supported only by a coerced confession, and the third involved charges of judicial misconduct that led to the resignation of two justices of the Illinois Supreme Court. The second case was especially important to me because it provided me with a form of intangible compensation that I continue to enjoy today. Knowledge that my work in 1953 and 1954 had led to the release of a man who had been wrongfully imprisoned for over 17 years. At that time, I was one of three partners in a newly formed law firm in Chicago and received an appointment to represent Arthur Lafrana, who in 1938 had confessed to the murder of a theater cashier and been sentenced to life in prison. When I met him in his cell in the Illinois State Penitentiary 15 years later, I was originally somewhat skeptical about his claim that he had been handcuffed and hanged from a door at a police station and beaten until he agreed to confess. But when I asked him to describe the pain caused by the handcuffs, instead of referring to his wrists, as I expected he would, he described excruciating pain in his upper arms and shoulders. That conversation convinced me that he was telling the truth and motivated a more thorough search for corroborating evidence than I might otherwise have conducted. During that search, I found a contemporary unpublished news photo of Lafrana showing injuries consistent with the beatings he had described, and a medical record identifying abrasions on his wrists. The only explanation of his injuries that the police offered was that Lafrana had fallen down the stairs when he'd been allowed to use the men's room. That explanation was so incredible that it was rejected by the Illinois Supreme Court, which ruled in our favor. The role I played in freeing a wrongly convicted man was one of the high points of my career. As my friend Irving Morris, writing in his recent book about his work in a rape case that he tried in the 1950s, quote, "Even though my clients paid little, I know I have earned far beyond what I ever imagined I might receive from successfully representing them." Second, I advise you always to keep in mind the critical distinction between answering questions on a law school exam and answering questions posed by clients or potential clients. In the former situation, your answers are designed to show your professor how smart you are. In the latter case, your objective is to provide help to your interrogator. While the answer, quote, "I don't know," unquote, would not be likely to improve a student's grade average, it may well be the most accurate answer for a newly admitted member of the bar, and indeed for a seasoned practitioner as well. Your training in the law is not just the acquisition of black letter answers to common problems, but also, and far more importantly, the acquisition of skills that enable you to identify problems and then to find answers. Perhaps the reason that the ceremony now in progress is called a, quote, commencement, unquote, is to remind you that you still have much to learn. In my experience as a judge, I have learned to avoid being embarrassed by my ignorance by responding that, quote, "I haven't read the briefs yet," unquote, Young lawyers should never be embarrassed by acknowledging that they have not previously learned the answer to a specific question. Third, in my considered judgment, the most important asset that any lawyer possesses is his or her integrity. Young lawyers are often surprised by how often and how unexpectedly they are confronted with temptations to deviate from settled rules in order to provide an apparent benefit to a client. Years of practice taught me that the lawyers who do bend the rules in response to those temptations become known to other members of the profession, and even minor transgressions affect their standing in the community. Bluffing may pay off at the poker table, but in the practice of the law, it inevitably diminishes an advocate's effectiveness. If your word is good, and if you are known to have impeccable integrity, you will have a successful legal career. My appraisal of the value and the importance of integrity may not be entirely consistent with the recent Supreme Court decision in the United States against Alvarez. In that case, the defendant was convicted of violating the act of Congress known as, quote, the Stolen Valor Act, by falsely claiming that he had been awarded the Congressional Medal of Honor. A divided Court of Appeals for the Ninth Circuit set aside his conviction, and a fractured Supreme Court agreed that the conviction violated the Constitution. Writing for the plurality, Justice Kennedy concluded that the defendant had a constitutional right to make his false claim. Justice Breyer, in an opinion concurring in the judgment, concluded that the statute was invalid. In dissent, Justice Alito stated that the court had held, quote, that every American has a constitutional right to claim that he has received the Congressional Medal of Honor, unquote. In a speech to a bar association group a few months ago, I briefly commented on the case. After referring to the fact that none of the opinions in the case had even cited Justice Brandeis' comment on the importance of the teaching function of Supreme Court opinion, I said that, quote, the plurality's announcement the defendant had a constitutional right to lie about his military record sends a terrible message to the youth of our nation and to the general public as well. I then said, while I agree with the reasoning and conclusion of Justice Alito's dissent, it is important to note that the first sentence in his opinion is inaccurate. The court did not hold that every American has a constitutional right to claim to have received that singular award. While 4 justices signed an opinion reaching that conclusion, Justice Breyer, joined by Justice Kagan, merely held that the statute was invalid on a novel theory of overbreadth. There is a world of difference between a holding that a particular statute is invalid because of its potentially harmful applications and a holding that the Constitution protects a right to make a deliberately false, worthless statement. Since making those remarks, I have had second thoughts about my endorsement of the reasoning in Justice Alito's dissent, which relied, at least in part, on the notion that Alvarez's false claim had diluted the value of the Congressional Medal of Honor by incorrectly indicating that the number of heroes who have earned it is larger than it really is. But if that is the public harm that the statute was intended to avoid, and if that harm is sufficiently serious to justify a criminal sanction, the statute should also have made it a crime to falsely state that a friend in Topeka has a neighbor whose cousin earned the medal. Furthermore, there are fewer than 100 living recipients of the Medal of Honor. As the majority opinion noted, quoting a brief by the veteran of foreign wars, there is nothing that charlatans such as Xavier Alvarez can do to stain the medal winner's honor. And in the internet age, it takes mere seconds to determine when someone is lying about having received the military's highest award. The statute also covers more than just the Medal of Honor. it criminalizes those who falsely claim any military award. Each branch of the armed forces bestows approximately 70 such awards, and some, like the Silver Star, have been awarded over 100,000 times. It is difficult to see how a false claim to have won such an award would have a dilutive effect. On reflection, while I adhere to my criticism of the notion that Alvarez had a constitutional right to make his false claim, surely he could be enjoined from repeating it, I no longer agree with the dissenters. As I'm sure you understand, my purpose in digressing to talk about my changed views about the Stolen Valor Act is to provide you an example of my fourth bit of advice for lawyers who are younger than I. When you make a mistake, don't be afraid to admit it. Let me close with a brief comment on a practice that all of us should condemn. Over 50 years ago, in a case arising in Tuskegee, Alabama, the court unambiguously condemned the practice of designing bizarre electoral districts to disadvantage racial minorities. More recently, the court extended the prohibition to include cases in which the legislatures intended to enhance the political strength of the minority. Even though political gerrymandering also plainly violates a state's duty to govern impartially and could be prohibited by applying the same standards that the court has applied in racial gerrymandering cases. Justices have refused to apply the rule against racial gerrymandering to political gerrymandering. No justice has ever argued that the practice of political gerrymandering serves the public interest. In your future careers, whether as members of bar associations, as litigators, as legislators, or as judges, I urge you to place a higher value on the interest in impartial government than on the partisan interests served by political gerrymanders. If you correctly define the duty to govern impartially, you can put an end to a practice that neither scholars, legislators, nor judges have even attempted to defend. Lawyers who are capable of identifying and prohibiting racial gerrymanders should be able to put the quietus on this widespread and malignant evil. I shall close by repeating my congratulations and wishing you all the best as you move ahead in our respected profession. Thank you.
Justice Stevens, we want to say thank you very much on behalf of the entire class for coming to speak with us. It's a very special thing to have someone of your caliber. So, in a small token of appreciation, here is a UCLA Law sweatshirt so you can fit in with all of us. And now it is my honor to present to you the student speaker representing the JD class, Grace Huang.
My fellow classmates, good afternoon. You know, I think I might have done too much trial advocacy and moot court because it took me all my strength to not start with, "May it please the court." Law school is powerful like that. I remember before attending school, speaking with an attorney, and she told me that law school changes the way you think. She said it's like someone taking a stick, scrambling up your brain, and remolding it. I remember what she said not only because it was a rather graphic image, but because after the first couple weeks of school, I could see what she meant. I remember for weeks during first semester how I could not sit in a car and look out the window without thinking, "Tort, there's a tort, there's another tort." Or how one day I actually sat scrutinizing my apartment lease, wondering if it was a valid contract or if I could somehow argue there was no meeting of the minds in agreeing to have a shower head with the water pressure of a drooling baby. But beyond the power of law school to make me fixate on roadside dangers and paragraph 9 of my apartment lease, Law school has given me the power to change lives. Now, mind you, as those of you who know me know, when I say lives, I'm talking about the lives of turtles and trees. But it's a statement that holds true nonetheless. Law school is an enabler. It gives you the power to give advice to someone facing eviction or jail. It gives you the power to merge Fortune 500 companies. It gives you the power to leave court thinking, lawyered. It's rather remarkable when you think about how much power we each will hold. And what we do with that power is entirely in our hands. After this day, there will be no more structured curriculums, no more tests, well, minus the bar exam, but at the very least, no more Socratic method on the footnotes. In fact, for those of us who went straight through from undergrad, this will be the first time in 20 years that we will not be students. 20 years. Law school marks the end of this long journey of schooling, but I want to make sure that all our years as students do not simply blur together. Our time in law school was quite different than any other educational experience we have had before. And as a former Trojan from USC, I can't believe I'm saying this, but I'm gonna miss UCLA. I'm gonna miss the chewy, steamed vegetables at Louval, the soothing noise of the metal chairs scraping along the cement floor, the random temperatures in the law school library and the classrooms, and especially the flooding of the bathrooms into the courtyard. I think all those aspects really gave the school character. But in all seriousness, UCLA Law has become like a home to me. My friends, my peers, and my professors have made this place more than just a building. I've found people I truly respect and admire, both for their incredible intellect and their humility. I've told other people this before, and I still believe it. I think if you are dead set on going to law school, and there is no way that you will change your mind, then I can't think of a better place to go to school than UCLA. We're a relatively happy bunch, speaking in comparison to other law schools, and there's a level of collegiality and non-competitiveness that I at least have really appreciated. I remember during my first summer internship, speaking with a fellow intern from a different law school, and telling her about my section, Section 2, and about the Facebook group we had, which we used to share stories, jokes, outlines, whatever. And her response was simple awe and amazement. She said there was no way she and her section mates would have ever created a Facebook group, much less crack jokes with each other. After that conversation, I really took a step back and realized my time in law school hasn't been that bad. And since that time, it's only gotten better. Not just because I could guarantee I would never have class before 11 a.m. or on Fridays, but because I learned so much about myself, about the law, and feel empowered now to change lives. And so, before I go, I just want to say thank you. Thank you, parents, for somehow standing by us when we agreed to take on 3 more years of debt, or for pushing us to go to school because you saw the best in us. Thank you, professors, for always having your doors open, and for even, at times, taking us to the faculty center to eat some real food. Thank you, alumni, for staying connected to the law school community, and for serving as our mentors, answering questions about school and about life. Thank you, Keith, the library security guard, for seeming to somehow learn all of our names, and for giving us a pick-me-up with a high five or a fist bump as we enter the law school library. Thank you, Los Angeles, for giving us a beach to run to, for mountains to hike through, for sun 360 days a year. But most of all, thank you, my fellow classmates, for making law school more than just a blur, for making law school 3 years to remember for a lifetime. Thank you.
Thank you very much, Grace.